Everyone here? We're good? All right. It is September 10th, 4 p.m. We'll bring to order the regular meeting of the Salina City Commission. Could we have a roll call, please?
Mayor Ryan.
Here.
Commissioner Davis.
Here.
Commissioner Hay.
Here.
Commissioner Hodges.
Here.
Commissioner Hoppick.
Here.
If you're able, would you please stand? We'll have a pledge of allegiance and a moment of silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much.
Mayor Ryan,
Yes, sir.
I would like to make a motion that we add at the end of the agenda a motion for a executive session to discuss non-elected personnel.
Is there a second?
Second.
Been moved and seconded to add that item to the agenda.
I'm sorry, where does it come in? After 8.1 then? Before
Yeah,
other
the other-
business or after other business?
We can put it after 8.1. My intention is to move 8.1 up after 7.7. And we will also be moving 7.5, I believe it is. Is that correct? 7.5 up after the, between public hearings and the consent agenda. So we're making a couple agenda changes there. But it will indeed put your request, Mr. Hay, at the end. So we will consider your request after, it will turn out to be after 7.9, and we'll move 8.1 to after 7.7.
So, Mayor, with respect to other business, would you like to do that after the
And we'll do
executive
that
session? or-
after, well, let's do your motion, Mr. Hay, after other business, because we may well have some other business, so let's just take it up at the end. Okay. That may complicate that. Very good. Now, we get back to where I was. Pledges, awards.
You need to vote on that?
Oh, we need to vote. Yeah, there we go. Is there any more discussion about that item? If not, all those in favor say aye.
Aye.
Any opposed? We'll add that to the agenda. Then, awards and proclamations. Do we have any awards and proclamations today?
We do not.
Okay, thank you. Citizens Forum. We'll move to Citizens Forum. It's an opportunity for anybody that'd like to address the commission on an item of interest to come forward and speak. You're welcome to come to the podium.
My name is Lori Troe, 740 South 9th Street. I just have something to say to several of you commissioners and mayor. So to Commissioner Hoppick Davis, Hay, and Mayor Ryan, do you remember who you are supposed to be working for? It seems to me that you do not. You were elected to work for the betterment of the city of Salina and all of our citizens. You do not just work for the deep money pockets that paid to get you elected so they can get special perks. In the last 9 months, I have been both appalled by and ashamed of the four of you. The actions that have been made by you, the words that have come out of your mouths, and the decisions that you have made prove to me over and over that you care nothing for the city of Salina as a whole and the majority of the people you were elected to represent. As a city commissioner, you need to be the type of individual that A, listens to all viewpoints of all citizens, B, studies and researches each item that comes before you, C, makes decisions that are fair to all citizens, and D, puts their personal beliefs and feelings aside when serving as a city commissioner. I implore you to change your mind, thoughts, and your actions while serving as a city commissioner to work for all citizens of our great city.
Ms. Troe? Are there others that would like to address the commission?
After that, I'm going to be a pussycat. My name is Bruce Moore. I live at 142 Sites, and I'm here again about the animal shelter ongoing controversy. I think it helpful if we look back and see how we got to this position so that we don't get here again. When the city inherited the animal shelter from the county in the divorce, you got something you hadn't had in a while, a functioning animal shelter with animals that needed to be fed, housed, and medicated, a whole new bunch of employees, and a bunch of statutes, rules, and regulations you'd not complied with for a long time. And you had nobody trained to run the boat. Dion hired Vanessa because she knew how to run the operation. She was experienced in animal welfare. She had worked at our shelter both as a volunteer and as a paid animal control officer, and she had experience in running a shelter. He said, go make the shelter better, and she did. She did really well under Dion's leadership, and when Dion left and Steve Hardesty took over, she continued to excel because Steve recognized in her that she had passion, she had drive, she had ambition, and she had the knowledge to take the shelter to the next level. He encouraged her, and the shelter continued to grow and become a model and a beacon across the region. The only thing that's changed is her supervision. And maybe it's the quality of her supervision that needs to be questioned and inspected here rather than her conduct and her performance. This shelter is not your typical business enterprise. They have no control over the number of animals that come in or the number of animals that go out. When they come in, no matter how inconvenient it may be. And they have to be cared for. They have to be tended to. They have to be medicated. They have to be watched. They have to be domesticated. They have to be adopted out. It's a lot of work. And you need somebody that knows that operation to run the operation. You don't need a bean-counting bureaucrat. It's not your typical business model. If you think that having Vanessa go is going to solve things, you are sadly mistaken. This shelter is not going to do as well under the bean-counting bureaucrats as it's done under Vanessa. They don't have the drive, they don't have the vision, they don't have the goals of making the shelter better. They only want to grow their resume for a few years and move on to another city. If you think that replacing Vanessa is going to be easy, I'm sorry, Mr. Ryan, am I boring you? I apologize. If you think replacing Vanessa is going to be easy, then you're sadly mistaken. Finding somebody with that drive, ambition, and knowledge is not going to be easy to find, particularly at what you pay. And if you think getting her out is going to solve anything, all you've done is sentence the shelter to a slow, lingering, dying demise. And that's just not fair to the animals, and it's certainly not fair to the city. Secondly, there was an email you folks should have received back in June from a William Chevy, who had a number of insights to share about the crisis then being presented to the city council. You were being asked to retroactively approve increases in spending authority over an animal cruelty case. And Vanessa supervisors knew about that all along. They didn't convey it up the chain of command. Again, maybe it's the supervision that needs to be looked at here rather than the conduct of Vanessa. Her conduct has been recognized by a district court judge as being reasonable and appropriate under the circumstances. So that email was supposed to just be a shot across the bow to get you folks thinking and talking and maybe asking some questions and not just accepting Mr. Gage's explanation for how you got here. The identity of Mr. Chevy wasn't supposed to be an issue. It wasn't supposed to be a distraction. Well, at the last meeting, John Blanchard told you he was William Chevy. Well, I'm William Chevy too. William Chevy represents the voice of people that are concerned with the trajectory of the animal shelter in this city. Under the last two supervisors, Vanessa and the shelter soared. Under the current supervision, the shelter is going to tank. Have the current supervisors done anything to alleviate the manpower shortage they created by lopping the head off that organization? Have they been over there once? Have they rededicated any other parks and rec personnel to help cover the shortage? No. Have they inquired about the mental well-being, the morale of those employees? No. Let me tell you what happens when people get overworked and their morale is down. Accidents happen. People lose focus. They get hurt. If you don't have supervisors in place that recognize that and want to address it, then you don't have supervision. And that's what they have right now, no supervision. So William Chevy wasn't supposed to be the point. William Chevy was just supposed to be a mechanism to get the word in front of you. If it didn't work, then we, William Chevys of the world, apologize. But that wasn't supposed to be the point. The point was to be ask questions, inquire. Don't accept at face value what somebody's handing you, particularly if it's a bureaucrat trying to cover his own backside. Thank you.
Are there others that would like to speak?
Good afternoon. My name is John Blanchard. I live at 1117 State Street. I guess it's a pussycat is a hard act to follow, but Mayor Ryan, what was it that you called me, a feral cat? Was that correct? So I'll just be a feral cat here today. I want to talk about what level of importance all of you put on this animal cruelty matter, because on June 25th, none of you really wanted to talk about it in public. I suspect, and I mentioned it last week, I think you guys talked about it in your executive session for 85 minutes. I think you talked about the spending authority being exceeded. I think you talked about actions that staff and the city attorney took. I think you talked about, obviously, I think it would be within reason to talk about whether it was constitutional or not. I think you talked about that on June 18th. What I did hear was a lot of speculation on the part of the former city manager, who I think quite frequently liked to fancy himself an amateur lawyer. And if you go back and look at the videotape from June 25th, you're going to see a lot of the judge is going to have to weigh this and the judge is going to have to weigh that based on the decision made by, it looks like, because lack of any other credible evidence shows that the city attorney and I'm just going to say the office, not the person, is the entity that made the decision of the direction that the animal cruelty case was going to take. The part that I find troubling was on this Friday, there was a hearing because the defendants had made a motion to dismiss. And although all the conversation on the 25th centered around a lot of it, whether or not this statute was constitutional or not, and I don't want to misrepresent the words, but I believe the words were by the city attorney that while he felt he was no expert in the criminal statutes and proceedings, that the Chapter 60 civil procedure was Law School 101. And I just have I would hope that you guys would ask the question, but you haven't. Have you sought an attorney general's opinion of whether or not the Chapter 60 civil proceedings are unconstitutional within the statute? Because if I were a legislator, I'd be a little bit offended by the conversation that took place on the 25th. Also, I would have expected that at least, well, one of you, Commissioner Hodges, was at the hearing. And it's not news now, but the trial is moving forward. Okay, so all this speculation about it being unconstitutional and so far evidently hasn't gotten the attention of the Judge Young. So I would just ask that, and I did see one of you, Commissioner Hoppick, I saw you in the hallway after the hearing, and I wish you would have been up there for that hearing, because you guys say that you can't say anything here, but there are certainly ways that you can show that you do have an open mind. One way of having an open mind would have been to show up at that trial, hear what the arguments were for dismissal, and realize that not only did Vanessa Cowie do what she was hired to do, but that the Salina County Sheriff deputies did their jobs very well as well. So disappointed that none of you thought it was important enough to make it there. Disappointed that because it was being argued that there were questions of constitutionality that, and it was only 45 minutes long, that we didn't have some sort of representation. Was the third-party counsel that you're hiring to look at this matter, was that third-party counsel, to your knowledge, did they attend that hearing?
Yes.
They did, okay. I didn't want to speculate because I don't know who that is. Anyway, it was just disappointing that you weren't there because I don't know if Chapter 60 Criminal Procedure is Law School 101. And I don't know what you guys talked about back there for 85 minutes, but I can tell you this. Governing Body 101, you know what that, CORA? The CORA laws, the COMA laws, that's Governing Body 101. So some of the comments that you made, Commissioner Hoppick, tend to show your hand a little bit that you guys talked about an awful lot more in there than just the statute. So thank you.
Are there others that would like to address the commission?
Hi, Nicole Crow, 231 South Clark. Just here, going to continue to come here until you guys do it. I want you to reinstate Vanessa. The animal shelter is the one suffering. Their staff is suffering over there. The volunteers are suffering. They need leadership, and there's no leadership in Chris Cotton, and he needs to go.
Get rid of it.
Anyone else like to address the commission? We'll move on from that item and go move to public hearings and items scheduled for a certain time. I think we have none. The
Excuse me.
consent agenda, please.
Item 6.1, approve the minutes of August 27, 2018. Item 6.2, consider acceptance of an offered public utility easement dedication from HMH of Salina LLC in the Highland Meadows Hamlet Woodlands Edition.
Is there a motion for the consent agenda?
So moved.
Second.
Been moved and seconded. We approve the consent agenda. All those in favor say aye.
Aye.
Any opposed? We'll bring 7.5 up to the top of administration. And who is giving us the...
Mayor, if I may, I might preface that a little bit. The reason for requesting that it be moved up is it is a grant application that needs to be postmarked today. So we're trying to expedite that before the opportunity to get it postmarked passes.
Well, thank you for clarifying that. You had explained your reasoning. I failed to say so.
So on the presumption that it is approved, we may need to ask the mayor to sign the document upon approval as well.
Yes. Yes, thank you for that. Yes. Thank you, Mayor and Commissioners. With the meeting not happening last Monday, and it was quite a bit of work to prepare this packet that's going to KDOT. It's a lot of stuff that we've done. Luckily, Martha and the Smoky River Renewal consultant HDR has done a lot of work, to put together documents for as we go through the design, kind of the 30% design process. So we tried to pick a project out of that possibly would meet some of the transportation alternative guidelines and have a chance at being funded. As you read the blue sheet, the idea this year is there's a lot less money available. It's very competitive. A lot of cities in the state are excited to try to submit for trail projects or safe routes to school, historical or archaeological type projects, scenic, environmental. Those are the categories that the Transportation Alternatives Program funds, which is basically non-street work or things that related to transportation, but not the normal modes of transportation. So it's been a project or a program over the years. We have received some funding, our wayfinding projects and interstate kind of landscaping that we did a few years ago, which was, that was back in the 2010 timeframe, so the time is moving fast, but that was about 7 or 8 years ago that we did get some funding from KDOT for that, as well as our first levee hike and bike trail from Crawford to Magnolia was done under this program. So those are the kind of projects that the city has gotten before, other places around the state as well. So we were hopeful that some of our river Trail would be a possible option for application to this program. So it took HDR a while to put it together and worked on it this summer, as well as the last few weeks to finalize it and get it ready for today, which today is the deadline to turn it in. And wish we could have done it a little sooner, but we appreciate you considering this today. Really, for the projects around the state, we're in the 5,000 population to 200,000 population, so it's a lot of cities are going to be competing for this. So I don't like to say that all this work is going to, hope to get us some funds, but it's a competitive program. We hope it does. We feel like a lot of times when you give them a program such as this, that is, we've done a lot of public involvement. We have a master plan. We have some plans. We have survey. We have a lot of things that do help, we believe, in the selection process, because they don't want a project that's, just an idea. They want something that they can actually build, because then you have to start a 24-month process. If you're even notified of getting the funds, you have to get right of way and get plans complete and get all the utilities. Really, it's just a long process that go through the federal process to get it done. So we feel like we look pretty good because we have some of that already done. We're excited to progress that we've had so far. The part of the river that we chose, we feel like is the most impactful, was the Ohio crossing. That is currently, water doesn't flow basically because of that. That is the reason we don't have water flowing in the river to a certain extent. So a bridge there, a trail, we have a trail that goes to one side. We have trail connections very close to there in Kenwood Park. We have the YMCA property. We have some public park property in that corridor in some areas as well, which is kind of an odd section of just park property. We don't have anything in there currently, but it's a great place for a trail. So to connect Ohio through the YMCA and through to Kenwood Park and the Kenwood Cove area, I feel like is a very good use of the funds and has some merit and would probably score well. So it's expensive, and we did finally come up with the final estimates. 1.2 million is kind of what we came up with for a trail for the participating. And this is participating. We can only ask for certain types of funding. And so a lot of it we're going to, if we ever get to build the river, which the idea is that would be an area that we would build. Part of it would be participating from KDOT, and part of it would be non-participating, that would just be city dollars. But anything we could get from KDOT, they have the authority to award a couple $100,000 to 1.7 million, it looks like, for total in our category. So anywhere in between there, we'd hope we'd get something. So that's the idea. So as the maximum city allotment would be for a $1.7 million project, $350,000 would be our maximum 20% match. Probably would be something less than that. The odds of us getting all of the 1.7 are fairly low, but we are asking for 1.2, and then we have a couple of phases. They could fund a certain portion, or just give us a portion of any of the phases. So that is the request, and it goes in today, and we find out soon. Their selection process, they thought they'd know this fall, so it wouldn't take real long for us to find out if we got the money or not. And that it is a 2019 and 2020, it would be a 2020 project, basically. So the 2019 fiscal year has actually already begun for KDOT, so that starts next summer and would be July. Is that right, Jim? July starts the next fiscal year, so we're already actually in the 2019 fiscal year for KDOT. So I would stand for other questions.
Questions for Mr. Stack? Thank you. Is there anyone from the public that would like to comment on this item? Bring it back up here for action.
Mayor Ryan, I move that we approve resolution number 18-7600, declaring the eligibility of the city of Salina to submit an application to the Kansas Department of Transportation for use of Transportation Alternatives Program funds set forth by MAP 21 for the Smoky Hill River Renewal Greenway Trail Shared Use Path Project in Salina, and authorizing the mayor to sign the application.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Any opposed? That item passes 5-0. Did you want to bring me
Thank you.
something to sign?
Yeah, we have 2 items for you to sign, so we appreciate you guys, you all,
You'll quickly
doing this
bring it
now.
up here. I can probably sign. You've taught me how to sign things really fast.
Do you need the resolution? It's over.
Do I need to date it, or you'll do that? Just one there? That's it. Okay. Putting pressure on you today, Allison. Check and make sure we got the right thing there. Thank you very much. We'll continue on with the agenda then, 7.1. Guess we'll take that out. When the clerk is ready, 7.1.
Item 7.1, second reading ordinance number 18-10969, amending Chapter 38, Article 3 of the Salina Code by amending Sections 38-59 and 38-62 pertaining to contracts for vehicle towing and storage services.
It's my belief we have not had any further communication or input about this item. Is there anyone that would like to address the second reading of this ordinance today? If not, we'll bring it back up here for a motion.
I do have a couple questions for staff on this item, please. I'm assuming that these provisions, as well as all the contract provisions, apply equally to all servers, all tow services.
Yes, this sets up a bid process whereby services or towing companies can make application in response to our RFP process. So it applies to them and their eligibility to, make application in the first place. And then at the point that an award is made, other bidders that are qualified get the opportunity to match the service in terms of the service provided at the same rate. And that then becomes the towing rotation that the police department uses. So there's different touch points in terms of how a contract provider might get involved, but they would all be held to the same standard to be eligible, and then they'd all be held to the same standard if they make it on the towing rotation.
How often are the contracts renewed? Is that an annual?
Every 2 years.
2 years? Okay, thank you. How do we monitor to ensure compliance?
I'm gonna,
And I'm
rather
sorry,
than,
I think that maybe
daisy
you need
chain
to come
this,
up and
I'll ask
answer
Mr.
those
Pruitt to
for
come
me.
forward.
Yes, ma'am. Wayne Pruitt, Salina Police Department. When the RFP goes out and they come back, we go out, the police department goes out, and we do inspections of each and every one of those applications. So every contractor out there that one's on, we'll go out and do a site inspection, and that happens every 2 years.
Okay, so in terms of following up between the 2 years, like, let's say you wanted to ensure that the towing office was open during the given hours that they're supposed to be open per the contract, is there any monitoring of, say, the hours that they're going to be open, or the charges that they're charging when they're doing city services to make sure that all of that complies with the contract?
Yes, ma'am. We have gone out, and I've had patrol division, because they're out and about, do spot checks. We've had complaints in the past of this business is not carrying business hours. So we go out and we have our patrol who's working that area check to ensure that those business hours are being carried. If anyone calls and says, we don't feel that the rates are fair, those complaints come to me.
Okay,
So
and so
they-
you have
they
an
bring-
opportunity to review the invoice and make sure that the charges that they're applying are being applied correctly?
Yes, ma'am. We ensure that they're fair across the board. And, there have been some discrepancies in the past where a company was charging mileage. You can't do that. Inside town, inside the city limits, we don't get charged as tow mileage. Out in the county, if it's further, outside the city limits, there is that capability.
Okay, and then in terms of penalties for violation of these provisions, and there was specifically in 38-62, I think it was section 12, there's a social media clause, and it was forwarded to me over the weekend by someone from my church that at a recent traffic fatality out on East Crawford, that the responding service actually was Snapchatting live, and I don't use Snapchat, so if my vocab is not where it should be, but who would I take that concern to in terms of potentially a fatality being posted
Right.
about on social media prior to notification of the family?
Yeah, that sounds like a valid concern on my part. I would suggest it starts
Okay.
with the city manager, and it's going to quickly end up
Okay.
with Mr. Pruitt.
Okay, thank you.
And Commissioner Hodges, I'm aware of that. That was a highway patrol that worked that accident. I don't have control of the highway patrol on that end of it.
Okay, because it took place outside city limits.
Yes, ma'am,
so
I
then-
did, I did look into that because it was
Okay.
brought to my attention also. And I'm aware of the company, I'm aware of what happened, and,
And that's an important point of clarification.
Right.
This ordinance regulates their activities.
Their conduct.
While they're responding to a call out from being on our tow service rotation for an accident that PD has reason to call them out.
Okay.
It would not apply if a private citizen called them to the accident. Uniform requirements, any of that would not apply.
I just want to, excuse me, I just wanted to make sure, and while that accident may not have been within, our purview, I think we need to be cognizant of the fact that it is one of our service providers, and they may need a refresher on what our expectations are from them, because that's just completely unacceptable.
yes, ma'am. And actually, the RFP is out right now for the tow contractors. And when I go out to the wrecker companies, and if they are accepted, this will be imposed upon them, impressed upon them. This is what we're going to do. This is what we expect of you. We want no less than that. If you exceed your authority out there, we will. There will be consequences for their actions. And we've had this over the years, the business hours or not answering phones when on call. We check into every complaint is important to us, and we want to validate.
With respect to the
Thank you.
timeliness of their operations, PD's a 24/7 operation, and it's kind of like a random audit by the time they make contact on a case-by-case basis to make sure they're answering the phone and they're conducting, keeping their office open, because they can get contacted by us at any time.
Thank you very much.
Yes, thank you.
Thank you very much. Any more discussion on this item? Is there a motion?
Mayor, move approval on second reading of ordinance number 18-10969.
Second.
Been moved and seconded. All those, we'll have a roll call at second reading.
Commissioner Davis?
Aye.
Commissioner Hay?
Aye.
Commissioner Hodges?
Aye.
Commissioner Hoppick?
Aye.
Mayor Ryan?
Aye. That item passes 5-0. We're ready for 7.2.
Item 7.2, second reading ordinance number 18-10966, amending section 35-40.2 of the Salina Code that would allow movable signs and outdoor furniture to be placed in public alleyways in addition to front sidewalks, plazas, and arcades, and that would allow for staff review and approval of movable sign and outdoor furniture permit applications in the C4 district.
We have received no further communication on this item. Is there anything else from the staff or questions from commissioners? Anything from the public on second reading? Is there a motion for this item?
Mayor Ryan, I move that we approve on second reading ordinance number 18-10966.
Second.
Been moved and seconded. Do we approve on second reading? Have a roll call, please.
Commissioner Davis,
Aye.
Commissioner Hay,
Aye.
Commissioner Hodges.
Aye.
Commissioner Hoppig.
Aye.
And Mayor Ryan.
Aye. 7.3.
Item 7.3, resolution number 18-7597, appointing members to the Board of Zoning Appeals.
Mr. Trey.
Commissioners, I assume that you recall that this item was postponed for 2 weeks ago to this date-specific agenda, and so the Board of Zoning Appeals appointment was separated from the rest of the appointments out of recognition that the mayor was proposing appointment of a family member of a commissioner. So at that commissioner's request, we created the opportunity for them to recuse themselves. One thing that I noted in the staff report, but we want to be sure to note for your benefit as well as the public, that prior to that August 27th meeting, I was approached separately by Mayor Ryan and Commissioner Hoppig with the stated intention of confirming whether there was any potential for a conflict arising from a city commission consideration of a Board of Zoning Appeals matter. And you may recall, I got asked that question at the August 27th meeting, and I responded the same way I did to the mayor and Commissioner Hoppig, that I did not see that as a conflict. I responded that I didn't foresee a conflict since the Board of Zoning Appeals determinations must be filed with the Salina County District Court directly. There's not an appeal opportunity to the City Commission, and they do not serve either in an advisory or appeal oversight role with respect to the Board of Zoning Appeals. I have every reason to believe that Mayor Ryan and Commissioner Hoppig were attempting to do their due diligence and proceeded on the basis of the answer that I gave them. And it's in response to a similar question that was raised at the meeting. City Attorney Greg Bankston hadn't even completed his sentence, and I knew where he was going, and I knew that I had overlooked a possible source of a conflict, and that is on a very remote circumstance, a City Commission could take exception with the decision of a Board of Zoning Appeals decision, and the City Commission itself could take up and or initiate appeal of that decision at the district court level, and that would leave the City Commission in a position of having to vote to initiate essentially a lawsuit to appeal that decision. I failed to point that out, or I failed to recognize that, and I won't bore you with the details, but ironically, there's only two instances that I know of where that's occurred. Once is in Salina, and once is in the last community I was city administrator in. So I don't have a good explanation of why that escaped me, but it did. So on that basis, then, that left you as a city commission deliberating a lot of what-ifs and a lot of scenarios that are no longer on the table due to Austin Hoppig withdrawing his application to the Board of Zoning Appeals and the mayor nominating someone else in his place. So at this point, I'd be happy to try to respond to the specifics if you think that's necessary, and I'd certainly do a better job of deferring to the city attorney on that question maybe. But with respect to the item that's before you, it no longer involves a family member of an elected official. It is the mayor's recommendation as it relates to appointment to the BZA. It's a standalone resolution for your consideration at this time, and with that, I'd be happy to answer any questions you might have.
Well, it's unfortunate we fell into this situation. I think the BZA's been around since about 1969, so that's one incident in 50 years. But I thank Mr. The younger Hoppig for offering his service to the community. He felt interested in doing that and having the advantage of learning what it's like to sit up here at the podium. But that be as it may, that left two openings, so I did appoint I can't remember the young man's name.
Brian Bennett.
Bennett, thank you, to the position of Mr. Trow, and I'm going to leave open the position of Mr. Hoppig and to see if we get some other EOIs. So that's the way I'd like to leave it with the commission's permission. I'd wait a couple weeks to see if we get some other EOIs on file.
I guess there's one other point that I intended to make. Coming out of that discussion 2 weeks ago, it was reported in the paper the use of the term unethical was used, and I understand why they might have characterized it that way, but I contacted the newspaper to explain that's not really the issue. It's just a matter of recusal. I believe a correction was run. I personally didn't see it when it ran in the paper. They seem to be a little hard to track down.
Well,
But
it's
I-
unfortunate that it was
yeah, that-
written as a quote, and I
Right.
don't think those words were said.
That's right.
And it was in a hypothetical situation if we had been in the situation that has happened once in 50 years.
Exactly.
So I really don't understand sometimes why the tape can't be used to get accuracy. But, yeah, I agree, that was unfortunate.
So we did ask for a correction. I was told it would be run. I believe it did run, but it's kind of hard to unring that bell when you've got a correction buried somewhere in a subsequent newspaper.
Any comments on this item?
I have a question for staff. So there were 2 openings, is that correct? And we're filling one of them with today's action?
Correct.
Looking back, it looked like we had initially 3 expressions of interest to fill 2 places. I guess my question is, and Mr. Tro here is present today, why we couldn't go ahead and fill Mr. Tro or put Mr. Tro in the other opening. I believe he's vice chairman of the Board of Zoning Appeals at the present time. So I was just wondering why that wasn't kind of an automatic fill.
Well, I don't feel that it is automatic, and I think it's my prerogative under the guidelines to appoint, so I am choosing not to appoint. There's nothing personal, it's just my private reasons, and then I'm going to hold that appointment until I see if we get some other expressions of interest.
Okay. And I'm not going to ask what, your reasons or anything. I'm going to turn to Mr. Bankston and ask, as a commissioner, and I don't have my rule numbers in front of me or anything like that, but in terms of going ahead and, wanting to proceed and seeing if there's any interest in the rest of the governing body to go ahead and appoint Mike Tro, what options do I have?
That matter is actually addressed in a specific resolution. I'm sorry, I can't refer to the number precisely, that has to do with board appointments. And under those rules, it is ultimately the prerogative of the governing body to make an appointment if it so chooses.
That's Resolution 167316, and it's attached to the staff report.
So in terms of going forward, should I wish to go ahead and ask the commission to consider filling both openings at once, the path forward for me would be to make a motion and see if it's seconded and then approved, or how exactly does that work? I'm sorry, you're going to have to spell it out for me.
Well, no, I believe what you've described is the manner in which one could approach that if a commissioner would be so inclined.
Okay, thank you. I didn't know if you wanted to ask for public comment before my motion or not.
Is there anyone that'd like to comment on this item?
Mike Tro, 740 South 9th. If I am not reappointed to the Board of Zoning Appeals, I would like to have it stated publicly as to the reason. The way it sounds like right now, well, there's something here, and I'm not going to talk about it. And I would just like to make sure that it's public, because I'm going to try to be on another board if I can't get back on the Board of Zoning Appeals, which I've really enjoyed the time I've been on there. I've learned a lot. But the way it sounds like right now, Mr. Mayor, you just don't want to do it, and you're not going to explain why. Personal reasons, okay, fine. Personal reasons, that's fine. But, these people out here and on public access, they may think that I did something, and I didn't do anything, but I just want to make that clear, that for some reason, you just don't want to reappoint me. And so I just want them to understand that I didn't do anything, okay?
Well, let me guarantee to you, Mr. Trode, there's nothing personal about this, and to the public out there that may be concerned, but it's still my private reason not to appoint you, and I'm sorry. Sometimes people here know, and my reasons are my own.
John Blanchard, 1117 State Street. You are a disgrace. My God, your private reasons, you are the most public office in this city. Your private matters don't matter. Okay, your daughter sits on the board that he asked to be reappointed to. Now, I also sat in your position and made some very difficult decisions based on the experience and the expression of interest forms of certain candidates. The fact that you are more than willing to reappoint a commissioner's son and appoint your daughter, and I might just point out for the public, this whole thing about you guys approached and said, boy, should we recuse and should we step out? How come you didn't do that back in May? Back in May, you appointed Austin Hoppick to the Board of Zoning Appeals. Why didn't you feel it necessary to recuse yourself at that point? Why did none of you ask any of the questions? I know the answer to part of that. Most commissioners, I was part of the crew that appointed your daughter. I didn't know it was your daughter. You never told anybody. So if you want the Journal to start making clarifications, then maybe you should clarify a few things. Maybe you shouldn't leave it to the newspaper to try and speculate, or Mr. Troe, or members of the public, to try to figure out what your personal reasons are for thinking that, oh, hey, we're begging people to apply for boards, and yet you're going to use a personal matter. I would encourage each and every one of you 4 commissioners to do the responsible thing, make a motion to overturn the mayor, who in the past has thought it was his prerogative to do whatever the hell he pleased up there, and rebuke him. Vote. This is a good man. And he has served with honor, and I don't know what your record of attendance is, but I got to tell you, I know it's a lot better than your record of attendance at board meetings. Okay? So I would encourage the rest of you, don't discourage people, good people, from wanting to be on these boards. And that includes Madison Miles, and that includes Austin Hoppick. Okay? I appreciate the fact that they chose to do it too. I wish they had done it when I was still on the board. I would have voted to approve them. But I see why you're wanting to not appoint family members now. And with all this thing going on with your personnel matters, it raises suspicion about what your motives are. Not the 4 of you, your motives. And so put your personal feelings aside, whatever they may be, and act in the best interest of the public that I know the rest of the 4 of you have, and I hope will continue to do. Thank you.
Thank you for your opinion, Mr. Blanchard. I understand your overriding goal is to make the Salina City Commission look bad and
You don't need any
get the
help.
public to question our motives. We are not, and I don't think any of us up here have any qualms of conscience. Madison Miles, it was my understanding, in the same way that I vetted that out with staff before, I was told the same things. That was not a problem. I also wasn't making the appointment. The mayor was at the time was making the appointment. She knew that Madison Miles was my stepdaughter. Dr. Davis knew that Madison Miles was my stepdaughter. Also, Jason Gage told me that all of the sitting commissioners understood that she was because I broached that with him as well. So at that point in time, that was fine. So, is there anyone else that would like to address the commission? I understand that your point of view is schadenfreude. I understand that you take pleasure. I understand.
Jason doesn't speak for me. He may speak for you, but he doesn't speak for me. So you want to allow me to get up there, or do you want to just badmouth people from the seat after they sit down.
If you'd like to
Yeah.
get up and speak a little more, just go right ahead, sir.
You said that Jason Gage told all city commissioners that Madison Miles was your daughter?
He informed me that all of the commissioners,
He
I asked him
informed
if
you,
the other
okay.
commissioners knew.
So you're
My
saying that I'm a
understanding.
liar when I sat up here and said I had no idea she was your
I'm
daughter?
not calling you anything,
Yeah,
sir.
you did.
No, I'm not. You may perceive that, but you perceive a lot of things differently than many people do.
And what exactly does that mean?
You can take that for whatever you'd like to.
Well, I take it for whatever. I take it that, you know what, I think you abuse your authority, and I think everybody knows that you're a bully, and you make innuendos. And you know what, Jason Gage, I can tell you this. He's no longer here. He doesn't speak for me. He never did. I know that maybe he spoke for you, but he never spoke for me. I spoke for myself. Okay? And did you ever tell me that your daughter was Madison Miles and that she was going to be appointed to that? I commend Commissioner Hoppick because at least on this last occasion, he said, you know what? I think it's improper for me to sit up here and do this. You sat there and said you didn't think it was necessary for him to recuse himself.
That's true.
That's true.
I still
You don't
agree
think
with
that there was any reason why Commissioner Hoppick should have stepped away?
Not based on the
And you don't think there
information
was
that
any
I...
reason why you should have let us know at the
If
meeting
you're
when we were
talking
voting?
about bullying and innuendo, then don't cut me off. There's a lot of people who have opinions about bullying and innuendo, and I will let the public make their own decisions between you and me about those facts.
Well, you're a
about those
public
items.
figure, I'm a private, you're a public figure, I am a private citizen. Okay? So don't put words into my mouth, but I just want to ask you the last question. Will you answer it? Because apparently you don't like me interrupting you. Did you think it was not necessary to let everybody know that was voting on there, at the time the vote was taking place, Madison Miles is my daughter, and we are appointing my daughter?
At that point, it was my understanding all of the commissioners knew that fact.
No, that wasn't the question I asked. The question I asked, did you not think it was important or proper at the time when the governing body was making an official action that you say something not only to us, because you know what, that's the problem that the public has with you. Oh, you tell Jason Gage, Gage tells all 5 commissioners so everybody knows and we don't have to let the public know what's really going on. Is that, I mean, that's pretty much the game plan, is it not?
That's your construction of it, and I
No,
don't think it's
I'm
accurate.
just asking you if my recollection is accurate. Is that what you're saying?
It is
that
not.
Jason Gage knew, he told all of us, so therefore it wasn't important that the public knew that you were appointing your daughter. You're saying that it wasn't important that the public know.
It was important that commissioners know. You may sit down, Mr. Blanchard.
I will.
You've expired your 5 minutes. Is there anybody else that would like to address this item? Thank you very much. We'll bring it back up here for action.
Mr. Mayor and Mr. Bankston, I trust you will correct my wording if I don't make this correctly. I would like to add to our resolution, number 18-7597, the name of Mike Troe to be appointed to the Board of Zoning Appeals.
In addition to Mr. Bennett.
In addition to Mr. Bennett.
The only thing that I suppose would be helpful, Commissioner, is if that was accompanied with a motion to approve. We don't have a, if I'm recalling correctly, we do not have a motion on the floor to approve the resolution.
Right, I was just, okay.
And I know you want to amend the
Right,
resolution,
okay,
but
okay.
we're amending before the main motion. Not that couldn't be combined.
Okay.
You're certainly free to make a motion that would include a modification, if that was your wish.
That is my wish, thank you. I would move that we approve resolution number 18-7597, appointing members to the Board of Zoning Appeals and including Mike Troe as one of the appointments, along with Mr. Brian Bennett.
Second.
Been moved and seconded. Is there further discussion?
My discussion would be, I think we owe the mayor the same courtesy that other mayors are being given. I know we have, when Mr. Blanchard was mayor, he did not reappoint myself to the airport authority for, I believe, to be personal reasons. And so I, at this point, will follow the mayor's recommendation when it comes to voting.
Other comments? It's been moved and seconded. All those in favor say aye.
Aye.
Any opposed?
Aye.
Nay.
Nay.
If the motion fails, do we want to restate the motion to appoint Mr. Bennett? Or-
Well,
Or do we not have, we don't have either in place now, the way the motion is stated?
the way the motion was stated, the motion obviously fails. If, I suppose, if that's the way we're going to approach this, the item could be added to this meeting's agenda by a 2/3 majority vote of those present, or could be added to your agenda for next week by a majority vote.
Well, Commissioners, what say you? We can,
I would move that we move resolution number 18, I'll wait for,
I apologize.
I'm going to make a motion that we move resolution number 18-7597, appointing Brian Bennett to the Board of Zoning Appeals to next week. Does that cover us?
That does.
Okay.
As I
And
say,
I apologize, and we're staffing this through a little bit, but, and my question rises from Robert's Rules of Order more so than Rules of Procedure. But had there been a motion to approve resolution, whatever the number is,
Before the amendment.
right?
We could have gone
And
back.
if there'd been, if that had been the main motion, and the motion to amend had been a separate item voted on and failed, then the conversation would fall back to the main motion, correct?
that is correct. I did not recommend that because, as best I can, I try not to affect outcomes.
Sure.
By virtue of parliamentary recommendations. The scenario you described, had the motion been made to approve and then subsequently a motion been made to amend that had prevailed, or the motion to amend had failed, then the main motion would stand. The way the matter was stated, I was concerned that to say that somehow the matter was, or the resolution was somehow resurrected, again, was beyond my parliamentary discretion, and that it would either take the same matter being brought back by virtue of a 2/3 majority vote for today or a majority vote for next week.
Just one question regarding that. When this comes back, this is not a simple matter of moving this resolution, but this action would have a different resolution number at the next time we hear it.
That would be
Because
the,
it would truly would be a new
technically
resolution.
be the way to approach that, I believe, yes.
And that this resolution was defeated the way it was presented. So it would have to be a new resolution.
Correct.
so we have a motion to restate the motion, Mr. Alpert.
I move that we, and I'm not going to use the resolution number, so it's going to be a different number. I move the appointment of members to the Board of Zoning Appeals, that being Brian Bennett, be moved to next week.
Second.
Been moved and seconded?
I'd like to make an amendment.
Or I'm sorry, if I may, Commissioner, it would not be a matter of moving it to next week. It would be a matter
Put
of
it on the
setting
agenda for
on
next
the
week.
agenda next week.
Okay.
I'd like to amend the motion that it be simply stated to appoint members to the Board of Zoning Appeals without name specific.
That might be desirable if we have some other EOIs come into play. That would allow me to consider anybody that had provided an EOI in the next week for consideration at that time.
Certainly. Was there a second to the main motion?
Yeah. I think Mr. Hayes.
Okay, Commissioner Hay did, yes. So then your motion to amend is certainly in order. If it is seconded, then of course it would then be up for consideration.
To withdraw the motion and restate it, or do you want to amend it?
Well, I would like to have all of the business done the next time we consider it. If it just has one name on it, then there's still a vacancy on the board. So I'd like the next time we resolve this, to fill that board up.
That would be the most desirable
Which would be the
situation.
reason I wasn't attaching any specific names to the action.
My hope was that we would at least fill the one slot and only leave the BZA with one open slot. Anymore, I think it would hamstring their meetings, but one, they certainly can do business and for a lot of its existence has. So I'd be in favor of that. If you want to amend it, we'll vote on the amendment.
I believe we're still waiting for a second
Second on the amendment.
Commissioner Davis's amendment.
I'll second that amendment.
Been moved and seconded, the amendment to vote on both selections next week, both spots.
To vote on the members being appointed to the BZA,
BZA.
no matter who they are.
Who it is.
Been moved and seconded, all those say aye.
Aye.
Any opposed?
Nay.
So the amendment carries. Is there any further discussion on the motion? All those in favor of the motion, say aye.
Aye.
Any opposed?
Nay.
That carries 4-1. All right, that item will be reconsidered next week in fashion, not a formal reconsideration. 7.4.
Item number 7.4, resolution number 18-7603, authorizing the interim city manager to exceed his $19,999 purchasing authority in advance to continue legal services provided by Fisher, Patterson, Saylor, and Smith for a confidential personnel matter.
Good evening, Mayor and Commissioners. The item that I'm bringing before you this afternoon is Resolution Number 18-7603, authorizing in advance the interim city manager to exceed his $19,999 purchasing authority in order to continue legal services provided by Fisher, Patterson, Saylor, and Smith for a confidential personnel matter. The city retained legal services provided by Terrell Mock with Fisher, Patterson, Saylor, and Smith to advise staff regarding a confidential personnel matter. The city is familiar with the work of Fisher, Patterson, Saylor, and Smith, including Ms. Mock, who specializes in employment matters. As you know, the firm of Clark Mize and Linville normally advises the city regarding personnel matters on an hourly fee basis in its role as legal counsel. The initial engagement of Fisher, Patterson, Saylor, and Smith was undertaken with the city manager's administrative authority upon the recommendation of Clark Mize and Linville in order to avoid any potential conflict of interest. Currently, the city has not exceeded its purchasing authority. The total time required and the resulting cost to the city is difficult to predict and will be determined by the course of the personnel matter. The interim city manager will need to continue to utilize legal services as he performs his role in this matter. I've included in my memo to you the fees for direct hire municipal work performed by Fisher, Patterson, Saylor, and Smith. Partner fees are $195 per hour. Associate fees are $165 per hour. Paralegal fees are $95 per hour. And law clerk fees are $55 per hour. In an effort to conform with the city's strategic plan, the city will provide the highest quality of services consistent with the governing body direction, available resources, and staff commitment to quality. As a fiscal note, the legal funds are funded through the legal services line item in the general fund, and I have confirmed with the finance director that there are sufficient funds to cover this expense. I have provided you a couple of possible action options. Option 1, adopt resolution number 18-7603, authorizing the interim city manager to continue utilizing legal services provided by Fisher, Patterson, Saylor, and Smith to advise the city regarding a confidential personnel matter. which may exceed his purchasing authority of $19,999. Option 2, you may decline adoption of Resolution Number 187603, resulting in the interim city manager not having the services of legal counsel related to this particular personnel matter. Staff recommends option 1, the adoption of Resolution Number 187603, authorizing the interim city manager to continue utilizing legal services provided by Fisher, Patterson, Saylor, and Smith to advise the city regarding a confidential personnel matter, which may exceed his purchasing authority of $19,999. And with that, I'll try to answer any questions you might have.
Questions?
Debating whether to even ask this question or not, it doesn't probably affect my outcome or my decision, or be dangerously close to exceeding that figure now.
The current number reported to me just today is we're just above $13,000.
Okay, thank you.
Other questions?
If it's helpful, that Lee, at the highest hourly rate, that leaves about 35 hours of services left. It's possible that we won't exceed that number at all, but didn't want to come here retroactively, wanted to be proactive.
Thank you.
I have some questions, but I don't think they're for Ms. Schuschler. I think they're more directed toward Mr. Scragg and Mr. Bankston. Particularly, how do we review, just for my own edification, how do we review the legal budget every year? Do we go through a budgeting process with legal every year?
Yes, it's a line item like any other budget line item that's taken into account.
Okay. And just in terms of looking through the, we appear to be operating under a 2007 contract with Clark Mice Linville for services. And we have Clark Mice Linville on a $200,000 retainer annually, paid in quarterly installments. And please, if that's not right, Greg, that was just the last one that I could find.
The retainer amount is actually $50,000.
Okay, but we have a base contract for 200?
No,
Okay, well,
no.
I'll have to take another look at the contract. Jason forwarded it to me some months ago, and I thought there was a guarantee of 200,000.
No. I'm not sure where that might have come from.
Because there was a specific list of services that were provided in terms of attending staff meetings, and, gosh, I don't have
Yeah,
all of those in front of me, and I
that-
thought that looked like a 200,000. My legal vocabulary may not be right. It may not be a
Well,
retainer.
no,
It was.
I'm sure it's, I don't know how much detail you would like to go into in that regard, but generally speaking, the $50,000, what's referred to as, I suppose, retainer, but it's identified in the contract as compensation for ongoing legal work, is recognition that the city was interested in having a certain level of predictability. For example, these meetings are all under that time, as are my participation in the executive agenda and executive staff meetings on Wednesday mornings in anticipation of these meetings in particular. And a certain number of hours that were expected to be provided within that $50,000. Now, we account for that on a monthly basis. And anyway, we certainly know that is to be abided by. And frankly, it has remained in place. The amount of time, as you might imagine, required for meetings has fluctuated over time and is more of an art, I suppose, than a science. The other work that is referred to, all other legal work, that which is performed on an hourly basis, is what this particular assignment. One thing about what we do, and I understand no one likes to think in terms of having to pay legal fees or legal services. I hope everyone understands one thing about our role. It is strictly advisory, and we do not have any unilateral ability to affect or to self-assign work, if that makes sense. There's nothing that we can say, well, we're just going to go do this today and expect to charge the city for it. That we simply try to be as responsive as we can to assignments given. And then, of course, this category of work, and that's the reason I suggested making that point in the blue sheet, the work related to the matter would have been hourly rate-based work. It's not substituting retainer work for or substituting hourly-based work for what would have otherwise been retainer work. That's the point I was ultimately leading to.
Right. I understood that would not be included under your normal scope of work. It's just, when I was looking through the last 5 years of our total legal expenses, and to be fair, we're not talking about strictly Clark Mize Linville. This is all legal counsel, supplies, continuing ed, all of that kind of thing. I see we range from a high of $670,000 a year to what we have budgeted this year of about $550,000. So we do, I think we obviously acknowledge very through our budgeted resources that we do make an investment in legal counsel. Dr. Davis asked about how much we had invested with Fisher Patterson to date. How much have we invested with the Clark Mize Linville in terms of this personnel matter to date? Do we have a number on that?
I'm sorry, I do not have that number.
Okay, but there has been work done by Clark Mize Linville on this matter that we should include if we're tallying up the investment that we're making in this personnel matter that would be included in addition to the $13,000 from Fisher Patterson.
I can answer that.
Okay.
Yes.
Okay, thank you. Okay. I guess my next question is, I would expect normally for you to represent the city in personnel matters, or is that something that whenever we have a personnel issue that looks like it's going to be challenged or get complicated, is that something that we typically in the past have sent to outside counsel?
No, to the point of what prompts any different approach. Depending upon the circumstances, as in terms of any of assigned work, we attempt to get that to the lawyer or lawyers that we believe are best suited to help with the particular situation, whether it's a personnel matter or any matter. And again, I don't know how much detail you want me to go into. There are certain times where well, I'll simply say there are different lawyers that, depending upon the nature of the matter, there could be different assignments among the lawyers at Clark Mize Linville. As to the, well, and now I'm not sure I'm sticking with your question.
Well, no,
It had the matter, if I had been advised that you might have inquiry about what is this reference to a conflict of interest?
Right.
And I'm happy to answer that
Yeah.
in more detail. In fact, having been advised that that might be a question, as you might imagine, in a confidential personnel matter,
Right.
one wants to be absolutely sure that any references are correct and appropriate, and I know sometimes when I'm being careful with my words, it can be tedious in terms of having to listen. So I will be happy, if I may, to read what hopefully will help on that matter of what prompted the recommendation. This is to the point of what is the basis for this potential conflict of interest that was referred to in your blue sheet. Potential conflicts of interest, or the potential appearance of conflicts of interest for attorneys, can arise under different circumstances. The most common arises when representation of one client would be adverse to another client. That is not the concern in this matter. Our firm does not represent the employee involved in the personnel matter. Our firm is most commonly called upon to assist with personnel matters when the employee is represented by counsel. Our firm was initially called upon to assist with the personnel matter when it became known that the employee's position in the personnel matter implicated opinions and actions by lawyers of Clark Mize and Linville. We promptly advised the city manager that the potential need for proceedings related to the personnel matter could potentially prompt the need for Clark Mize and Linville lawyers to serve as witnesses, and recommended that special counsel be retained. That's the scenario that prompted that recommendation.
Thank you. That's helpful. And because, outside counsel is obviously not particularly unusual. In the last several months, I can think of the redaction challenge that generated, I think it was like an $8,900 bill from Stinson Leonard. We had the eminent domain that was around 30 grand. The Qualig B new market tax credit thing, I don't know that I ever got anything on that. And then Fisher Patterson, which may exceed 20. So, yeah, my question was about the conflict, and that, thank you, I appreciate that answer.
I might, if I may add one thing,
Yeah.
the circumstances and the examples you gave, there are times when, well, any number of scenarios could potentially involve looking to other counsel. The one time, I think in the examples you just described, our firm represents Salina Regional Health Center.
Right.
And to my recollection, the only time that there was a true client conflict was when we had to obviously be watchful and careful for any appearance of a potential conflict of interest. Anyway, there are circumstances that we simply have to be watchful for as a private firm, and we try to hopefully handle those in the city's best interest.
If it's helpful, I would add, with respect to new market tax credits, that is a specialty nationally. And so when we conducted a request for qualifications leading up to the Fieldhouse new market tax credit application process, we identified the need of specialized counsel in that regard. So we retained a specialist.
Thank you.
Any other questions for staff? Anyone from the public like to address this matter? Being none, we'll bring it back up here for action. Is there a further discussion or a motion on this item?
Mayor, move we approve resolution number 18-7603, authorizing the interim city manager to continue utilizing legal services provided by Fisher, Patterson, Saylor, and Smith to advise the city regarding a confidential personnel matter which may exceed his purchasing authority of $19,999.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Any opposed?
Nay.
That motion passes 4-1. 7.5 we have had. 7.6.
Item number 7.6, reject bids for the replacement of 4 rooftop units for Heritage Hall located on top of the Tony's Pizza Event Center.
Mr. Cotton.
Good evening. Tonight I come before you to simply ask you to reject the bids for the replacement of 4 rooftop units of Heritage Hall. Originally, this was to be part of the renovation of the Tony's Pizza Event Center. The original concept was to try to integrate the existing 4 units to a different control system that would allow the staff to control the units from inside the building. After all the renovation work was done, we simply ran out of funding to do the project. Initially, upon initial review of the project's remaining funds by finance, it appeared there were sufficient funds to proceed with the replacement of the units as a whole, so we did go out to bid on those units. However, after further review by finance, it determined that the project has spent all the funding for the project, therefore we need to return the bid bonds to the firms that bid on the project.
Questions for Mr. Cotton?
So the long-range plan for this would be?
We will keep working to address it. We'll look for other alternatives to incorporate the units if possible. Otherwise, we'll come back next budget cycle and request funding to replace the units.
They're functioning?
They function,
well,
yes, sir.
yeah,
They function.
okay.
It's just not. They just don't. It's not convenient.
At the time, that whole project went through a lot of value engineering, and this was one that was kind of parked off to the side to see if we would have funds remaining, and we don't.
Thank you, Mr. Cotton.
Thank
Is
you.
anyone that would like to address this item? Bring it back up here to the commission for action.
Mr. Mayor, I make a motion, we reject the bids for the replacement of 4 rooftop units for the Heritage Hall located at the top of Tony's Pizza Event Center.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Any opposed? 7.6 passes 5-0. We will bring up under development business number 8.1.
Item number 8.1, application Z18-17, requesting approval of an amendment to section 42-59 of the temporary use regulations in Article 4 of the zoning ordinance to increase the allowable size of an on-site inventory storage unit located at a consumer fireworks facility, and consider companion requests to amend section 14-56.1 of the fire code to increase the allowable size of an on-site inventory storage unit in the fireworks ordinance. 8.1A, consideration of ordinance number 18-10971, and 8.1B, consideration of ordinance number 18-10972.
Hi, I am Chaz Coberly, appearing on behalf of the applicant Ken Wasserman of Norton Wasserman Jones and Kelly. And simply stated, yes, we're just trying to increase the on-site storage from 120 square feet to 424. It's really an issue of safety. The vendors don't really anticipate bringing in a lot more inventory. They already have statistics in order to tell them about how much they're going to sell every year. So it's not really about adding a safety hazard to each location. It's more about being able to pack up their inventory for safety concerns. One being at night they can put their inventory away, they can lock it up, it could be nice and secure so it's not just staying in their tent. And 2 being in case of weather emergencies. They could put all their inventory in a locked container or trailer so it's not destroyed by our Kansas weather conditions.
very much.
Yes, thank you.
Mr. Andrew, is there anything from the staff that you'd like to add?
Just by way of background, for your benefit, the original draft of the fireworks ordinance, which was done in January 2011, didn't make any provision for on-site storage at consumer fireworks stands. And at the request of fireworks vendors, the ordinance was modified by the City Commission to allow for on-site inventory storage up to 120 square feet. This size limit that was adopted does not appear to have been code-based, but it appears to have been based on a recommendation of the fire chief at the time to limit it to 120 square feet. So that's the way it's adopted. That's the way it has remained. The NFPA does not have a recommended size limit on inventory storage units. Our 120 square foot limit is local. And so we have received an application for a zoning text amendment to amend our temporary use regulations to expand the on-site storage available at a fireworks stand from 120 square feet to 424 square feet of secure storage. And that roughly corresponds to the size of a semi-trailer as opposed to essentially a U-Haul trailer size that we have now. The current fire marshal reviewed this request. Planning staff reviewed the request. It was determined that both fire code and zoning regulations need to be amended. But because it did involve a zoning regulation change, it was first referred to the Planning Commission for review and recommendation. And they conducted a public hearing on this matter and have recommended that the limitation be increased from 120 square feet to 424 square feet as recommended by the applicant. And so the effect, if this were approved, would allow effective next year to have Salina fireworks vendors keep a locked storage unit up to 424 square feet at their fireworks stand location, as long as it's at least 20 feet from the sales tent. And so your options would be to concur with the Planning Commission's recommendation as to the zoning ordinance change, or another option would be to increase the amount of storage, but not to the full 424 square feet being requested. If you chose either of those two alternatives, we would recommend that the companion ordinance amending the size limit in the fire code also be approved on first reading. And so if this change was approved, it would go into effect next fireworks season in 2019. So I'd be open to any questions we have. I do think we have a fireworks stand operator here as well, if you have any questions of them.
Dean, it's a minor point, but you speculated that the original 120 square feet was at the suggestion of the fire chief, and the fire marshal technically is a fire chief, but do we think it was the fire marshal at the time, or do we have reason to think it was fire chief?
Only because when I reviewed the minutes, I only saw Chief Mullick in there and
Oh, okay.
speaking. He might have been representing the views of his fire marshal, but he was the one that spoke on the matter, so.
Okay. Well, then we'll continue to blame him.
Questions for Mr. Andrews?
Like I
Thank you
said,
very much, sir.
if you have any questions of the stand operators, I do. Mr. Comey's here representing Farhoff Fireworks, if you have any questions from their perspective.
Any questions for the applicant? Any comment from the public? We'll bring it back up here for action. Is there a motion on this item or more discussion?
Mayor Ryan, I move that we approve on first reading ordinance number 18-10971.
Second.
It's been moved and second. All those in favor, say aye.
Aye.
Any opposed? 8.1B.
Mayor Ryan, I move that we approve on first reading ordinance number 18-10972.
Second.
Been moved and seconded for this item. All those in favor, say aye.
Aye.
Any opposed? That item passes 5-0. Thank you very much. We'll back up now to 7.7.
Item number 7.7, resolution number 18-7602, authorizing the interim city manager to execute a letter of engagement with Development Strategies for analysis of sales tax data relating to the Star Bond District.
Mr. Schrag?
Thank you, Mayor and Commissioners. You're going to be seeing a handful of Star Bond-related items in the coming weeks. You may recall we set the baseline for the Star Bond District and got Star Bond plan approval in 2015. So the legislative session of 2016, 2017, 2018, and now pending 2019 have all been opportunities for possible legislative changes to Star Bond regulations, and there's been speculation every one of those years that Star Bonds may be discontinued or significantly altered. This year, in addition to that, there's concern about interest rates and whether the feds may be raising interest rates and impacting the interest rate that would apply to Star Bonds. And probably the most timely item is now that we've gone through the primary elections and see that Governor Collier was defeated, it seems a foregone conclusion that the Secretary of Commerce may change following the 1st of January, and we still need approval of our bond issuance by the Secretary of Commerce. So there's interest, there's recognition on the part of our financial advisors and Salina 2020 and basically everyone involved in this process that it may behoove us to try to expedite Star Bond issuance before the end of the calendar year. So that's a decision that will be before you in the near future. Doesn't mean you have to, and we will staff you through the details of those considerations and the cost implications of that in greater detail at that time. But one of the tasks that we've identified is updating our estimate of the baseline sales tax generation. And so if you recall, Star Bonds are increment based, and so we have an approved baseline based off of 2015. I worked with the Department of Revenue in great detail to agree on that baseline, what sales tax generators and collectors contribute to that base. I won't go into great detail, but it was surprising to me how informal that data is. It was not straightforward based on everybody has an address and you check it for being within the Star Bond District. It was not formal in that company XYZ, as it is in the Department of Revenue's records, may not correspond to the doing business as name that's above a door, and they may be out of an entirely different state. So it was quite an exercise to sort out the businesses to identify that baseline. Now, in the intervening time, to update our feasibility study, we need to go back and revisit the businesses. Some of those may have changed, and also then identify what our most recent 12 months look like in terms of baseline sales tax generation. The baseline won't change. If we've seen growth from 2015, we'll get the benefit of that increment and being able to capture that increment. But for the purpose of the feasibility calculation, we need to update that baseline. Serving, and that's something that I did in the past and would do again, but serving in a dual role as deputy and interim city manager, and given the urgency of the timeline, we had talked previously about bringing in consulting services if necessary, and this is the first opportunity that I've elected to do that. So the item that's before you is adding a standalone engagement with Development Strategies, who's serving as our feasibility consultant for the Star Bond project already and has a standalone contract with us. But this is specific for the purposes of updating the baseline. And they've provided a cost estimate range based on what they know the task to be, ranging from essentially $4,000 to $6,760. In all honesty, we've been able to crunch the numbers well enough that I think we have an opportunity to keep that number down. I could be wrong, but I don't expect we're going to certainly exceed the 6,760 number, and I hope that it'll be significantly less. So with that, that's kind of the action item and the need for the action item. And when we talk about the conformance to the strategic plan, the downtown redevelopment initiative hits a lot of those, from being a city that's exciting, thriving, both economically and socially, being clean, attractive, and inviting, adding to the quality of life, being well maintained, having a downtown that's thriving and a vibrant place, being supportive of lifelong learning in the form of the KU Med School and encouraging economic expansion. With respect to the fiscal note, Development Strategies has provided the cost range estimate that I noted, and I hope to fall well under that. And while it's within the city manager's purchasing authority as a standalone item, if you combined it with the contracted services we already have with the development strategies, the two of those combined exceed the city manager's purchasing authority, which is why I chose to bring it to you. And ultimately, the funds will come out of the temporary notes, which fund the STAR bonds and then roll into the general obligation bonds that would be issued. So it's part of it's eligible for the STAR bond financing. As far as action items for your consideration, you could approve the resolution 187603 authorizing me to execute a letter of engagement with development strategies, or you could decline to approve that, resulting in myself and additional staff needing to perform that task. So I'd be happy to answer any questions that you might have.
Questions for staff?
Is our other contract with development strategies, is it completed? Or do we still have outstanding work on that?
There's a little bit of billable expense left, and the remaining tasks are one more round of updating their numbers and a presentation of their final feasibility study. So they've done the bulk of building the model, doing all the research, and they've provided an initial feasibility study, but much like the baseline, as we get close to that finish line, STAR bond issuance, they need to refresh those numbers and report out.
Right, I get that. I couldn't remember, what was the amount of the original contract? Just out of curiosity, since it was referenced, but I didn't remember.
I'm sorry, I thought I had it in the staff report. I believe it was 62,000, and I believe there's about 6,500 left to be billed.
Okay.
And they agreed they could meet your timelines necessary to
Yes,
move
in fact, I
this
think we have a conference
forward.
call scheduled day after tomorrow, assuming this all comes together. So it's aggressive, but they're aware of it.
Okay, and this is resolution number 187603, not 02?
Well, good question. I would
We got
refer
them
to the
both.
resolution number rather than my staff report. I could be wrong about that. Allison, do you know the correct number?
It says 2 here, but you did say 3.
But on the back
And
page,
my staff
it's-
report says 3, but the resolution itself is 7602, it looks like.
7602.
So 7602.
02.
My apologies.
Any further questions on this item? Is there anybody that would like to address this from the public? There being none, we'll bring it back up here for action or further discussion.
Just had one more quick question. It's tangential, but I think it's an easy answer for you. In regard to the alley, you gave us an update in your city manager report that said that you had touched base with the owners of the alley, and I just wanted a refresher on what items need to be in place to be considered commencement. We've seen the commencement of a construction trailer set there, but have we gotten a confirmation on their financing package, and have we gotten a construction timeline yet?
Yes, and I'm working off the top of my head, but guaranteed maximum price contract, confirmation of financing, typically the timeline's provided once they actually execute the contract, which they've done. So the construction trailer's on site, and they've made arrangements for contracted work to commence, with AT&T being the one that is probably the first one that's going to break ground. So knowing what I know about the project, I don't have any reason to think that they haven't technically commenced according to the terms of the transferee agreement.
Gotcha. So you're satisfied that they've
Yes.
materially completed that? Okay. Thank you.
Is there a motion?
Mayor Ryan, I move that we approve resolution number 18-7602.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Any opposed? That item will pass 5-0. 7.8.
Resolution number 18-7601, adopting the revisions to the city manager position description.
Ms. Fisher.
Thank you, Mayor and Commissioners. At last Wednesday's special study session, you had the chance to look at a proposed draft and also provide input and feedback on modifications. As stated in the staff report, the revisions that you received from me were primarily formatting as well as a couple of tweaks for language along the lines of ADA. So the input that was received, the language was integrated into the specific area of minimum education, training, and experience requirements, as well as updating the date and the resolution number to reflect the adoption. So I'd be glad to answer any questions, or if there are other revisions that are desired, to go back to the drawing board and bring those back to you as well.
I'd say you did a good job.
Same here.
Thank you very much for your work. Is there no other questions for Ms. Fisher? Open it up to the public for comment. And we'll bring it back here for action.
Mr. Mayor, I make a motion that we approve resolution number 18-7601.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Any opposed? That motion passes 5-0. 7.9.
Item 7.9, discussion regarding city manager profile and brochure.
Ms. Fisher.
Thank you. I don't have a lot of information to provide you, other than I apologize in the late receipt of the brochure. I expedited that to you approximately 10 minutes after I received it today. The city clerk's office did assist in attaching it to the online agenda packet as well, so that was taken care of as soon as possible this afternoon upon receipt.
One question, on the very back page, are the blank lines for the date by which resumes have to be placed online, and the other information, is that?
My understanding is when the rest of the process was to be determined, that Art Davis will work with you to determine what your timeline and
So that's
desired.
deliberately blank right now, then?
Yes.
Okay.
Yes, to be determined.
Gotcha. This is actually a very fun, exciting city to live in. I mean, people should,
It's good. It's a very good-looking piece of work. The comments from the commissioners or discussion?
Due to the late date of receiving it, I have to admit I didn't have a chance to go back and review it against our notes from last week, so.
Yeah, I don't think that I have much to add to that, because, yeah, I'm seeing this for the first time.
So shall we schedule this for discussion next week, or?
I haven't looked for every possible grammatical error, but I think we skimmed all those last time we discussed this, but it's, I think it's very nice, or if you want to take 5-10 minutes and look at it now.
Yeah, that's fine. Yeah, I think 5 minutes. I'd like to just look through it really quickly.
In that case, could I request 7 minutes so that we can?
How about a 10-minute break so we can look at it?
Take a 10-minute break and bring
That would
us
be
back
good.
at 5:55.
Thank you.
Well. Joe, do you want to do the executive session next and then come back? We'll have other business.
That's fine
We
with
can
me.
put the request next, or we can do it after.
That's fine with me, wherever you want to put it at.
Okay, well, we'll get to it. Mr. Schrag, come back.
Do I read that, or does Mike read that? Do I read that, or does Mike read that?
For your motion? Yeah, you can read the motion.
Oh, or I think here it is.
Oh, well, no, I think Hoppick can read this.
Okay.
Oh, okay. You don't have to, you just requested it.
Okay.
But the question is, how long will we need?
Let's say 15.
Okay. Tell Mike 15. We'll call the meeting back to order, please. We had a request for executive session.
I move the city commission recess into executive session for 15 minutes to discuss a non-elected employee's performance and status based upon the need to discuss personnel matters of non-elected personnel pursuant to KSA 75-4319B1. The open meeting will resume in this room at 6:12 p.m.
Now, excuse me, Vice Mayor, I may have gotten ahead of myself there because we didn't
Haven't
finish
finished.
the
It just
discussion
occurred to
about
me,
the
same
profile
thing.
and the brochure.
Wish I'd take that.
That dies for lack of a second, and we will finish the discussion.
I read it perfectly.
How's everybody? You did read it perfect.
I just got one question. How much are we in right now to Springstead Waters for where we stand at right now?
We are covered under the scope of services, so we would not exceed, and I can grab my agreement and my binder, but it would be the agreement that was approved, I'm going to say.
It's about 43,
about 6 to 8
4,400.
weeks
I
ago,
was thinking
Under
47, yeah.
somewhere in there.
Okay.
If you were going to relate any minor spelling issues, then on page 2, in the light blue area on the right, KSU's official name and the official name of the medical school are incorrect, but they're correct in the dark blue area just to the left of it.
Okay. And you're under the unique facts about Salina? Was that the section?
Yes.
The bullets? Okay,
Yeah.
I did flag that one.
Yeah, same thing on the dark blue. They mention Kansas or the School of Medicine in the blue, and nursing in the dark blue and not in the light blue. Minor.
Yep.
Also, I like the fact that we talked about not listing all the strategic plan and stuff, and I'm taking it that you verified they had the contact information correct in there, that it,
I will give it a once-over,
Okay.
just
That was-
before we
making sure they had the
get any other
correct.
revisions.
And then I had pointed out to you too about just making sure that the qualifications and experience align to our newly adopted qualifications.
Other discussion? Is there any action we need to take on this item at this time?
It just says discussion, so
It's-
I'm guessing.
We like what we see and approve the brochure.
Is that best done in a motion to approve?
That would probably be best for the record, yes.
I move we approve the brochure produced by Springstead Waters with the few corrections that we suggested.
Second?
Been moved and seconded. All those say aye.
Aye.
Any opposed? We'll approve the brochure. Now we're ready for executive session.
Right. I move the city commission recess into executive session for 15 minutes to discuss a non-elected employee's performance and status based upon the need to discuss personnel matters of non-elected personnel pursuant to KSA 75-4319B1. The open meeting will resume in this room at 6:16 PM.
Is there a second?
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Any opposed? We'll go into executive session.
presence of the city attorney in the room with us.
There a second?
Second.
Been moved and seconded. All those in favor say aye.
Aye.
May I clarify that the category of the
Same-
executive
same
session
category.
remains the same, just
Yes.
that you're asking me to join you for the personnel matter?
Yes.
Okay, so David said Mayor Ryan requested an extension, so what I
There will be no action taken. We'll move on to other business.
I have
Vice Mayor, yes, you have something for us.
one issue, and as I'm going to read parts of something here, and I will, and if you still have one, I'll get three.
Okay, thank you.
One for you, one for the clerk, and actually, and two for over there. I think I counted just right. 2 weeks ago, and I may find that I don't need to do anything, but 2 weeks ago, we took action to send back to the Planning Commission an application that would have resulted in, get the proper word, electronic changeable copy advertising signs, were basically electronic billboards. And the applicant had asked what the difference was between what he was proposing and what we currently have on Ohio Street outside of, I can say T-Peck East, and I can say Tony's Pizza Event Center. Thank you. And I was led to believe that the major difference was that our sign was for on-site announcements and advertising, whereas the billboard would be off-site advertising. I just happened to be driving down Ohio one night, not expressly planning to look at the sign, but I noticed there were advertisements for businesses other than T-Peck. And actually sat there and counted their Passenger Heating, United Airlines, Bennett Automotive, Blue Cross of Kansas, and I think our Salina Police Department. I don't know whether they get a waiver or not, but, and they were interspersed anywhere every fourth ad up to every eighth ad, so the intrusion was irregular, but it was there. The other concern I had was that in the proposals that were listed, should we have wanted to have an ordinance to allow those, would have set certain lighting and technical limits. It was suggested that the industry standard for display times was absolutely no less than 8 to 10 seconds. Our ads changed every 4 seconds. And it became obvious, at least to me, that one, our sign might actually be a digital billboard because it's advertising off-site premises or businesses, and it would not adhere to the to technical limitations that we would impose ourselves. So in effect, this sort of became a non-conforming sign. And I don't know if our decision on the aesthetic qualities of electronic billboards in the city of Salina would change any, but I didn't want the decision to be made on the assumption that what we have is different from what the applicant was proposing to have. And as far as the brightness, I've gotten used to seeing that sign. I don't know what a sign that emits less light would look like, if it would be less intrusive. But it just seems as though my decision, again, not counting the aesthetic values of electronic billboards, may have been influenced somewhat by misinterpretation of what we were allowing for ourselves. And more in the interest of being fair, I mean, we should treat someone else the way we're going to treat ourselves for the same product. So I don't know whether, now this has been sent back to the Planning Commission, and that may be all that needs to be done at this point. If there's, I don't know whether I need to have this issue or request a reconsideration to get before the vote to then immediately table it, to allow staff to look at it, or whether sending it back to the Planning Commission would suffice.
Well, I can try to speak to some of those. What came to you from the Planning Commission was a recommendation for prohibition. They staff had supported them, and they had considered and developed a regulation, but then they ultimately recommended prohibition. And so the action that you took as a governing body at that meeting was to essentially confirm what the Planning Commission had recommended in the way of a prohibition. And procedurally, that meant it needed to go back to the Planning Commission, be advertised as a prohibition rather than a text amendment for sign regulations. So I'll certainly open it up to the city attorney or Dean Andrew, but the action that you took was prohibition specific, and the information that we provided was to extend the moratorium to account for the timeline that it would take to advertise it, consider it by the Planning Commission, return it to the City Commission for action. And we intended to advertise that last week, but recognized that there was a week of play in the that schedule. So it's yet to be advertised, but if that was going to be broadened in terms of what you want the Planning Commission to consider, I expect that, much like we wanted to be conservative in our approach of taking the prohibition back to them, I think we would want to give them clear direction on the breadth of what you'd like them as a body to consider.
Right. And I did vote in favor of the prohibition. My moral dilemma now is I think our sign is probably improperly classified unless there is a way in which we're allowed. I don't know if those 5 advertisers are sponsors and that exempts them from having an ad on that board or not, but it seems as though we are treating ourselves quite different than we're treating someone else.
I understand your point and your concern, and it might be partly due to an overgeneralization in our conversation the last time we discussed it. I want to say last week, but that we didn't meet last week. But I think Mr. Andrews prepared to speak in greater detail. The Tony's Pizza Event Center and school properties are zoned as public zoning categories, and as we took up the Tony's Pizza Event Center sign and considered some of the school district requests for signage and their anticipated need for signage, we did customize that zoning category and that approach. As we approved the Tony's Pizza Event Center sign, we spoke to the controlling glare and the light levels and the timing. I can't tell you specifically what those were nor whether they're being adhered to. I know that the construction of the sign is such that it dealt with the light spill and the glare. But if I could, I'd like to ask Mr. Andrew to speak to the specifics of the zoning category and the difference in the categorization of the signs.
If I may, I've got 2 handouts that I would like to go over to help explain that. Here. This is a side-by-side comparison of the difference between the standard electronic message center sign and a digital billboard. And this drawing here will give commissioners a sense of scale of what the difference is between the sign at Ohio and Midway and what we would classify as a digital billboard.
Okay, thanks.
It would be fair to blame me for characterizing the sign at Ohio and Midway as an on-premise identification sign. I still consider it an on-premise identification sign. The city of Salina has never authorized a sign permit to be issued for a digital billboard, and we don't consider what is there to be a digital billboard. And as you look through these differences, we'll do our best to try to explain how we arrived at that conclusion. While it is correct and maybe not ideal that the operators of the TPEC sign have advertised businesses that aren't located on the property, the distinction is that an on-premise sign does advertise things that are taking place on the property, and that does advertise events that are occurring there. The other thing that is different is that that sign is owned, it's on property owned by the city of Salina, and the sign itself is owned by the city of Salina. So that makes it on-premise from that standpoint. The other thing this points out, the second item, is that signs that are considered to be billboards or digital billboards are regulated by the Highway Beautification Act in addition to local regulations. If we took that sign that's at Ohio and Midway, and we had an event center out on I-70, and we put that sign up, it would not be subject to KDOT or Highway Beautification Act regulation because they would classify that as an on-premise sign because it's located on the premises of the event center that it's serving. Notwithstanding that it might have some off-premise ads, KDOT would not regulate or have to issue permits for that sign. If a billboard was located out on I-70, they would. There are a number of cities that completely ban all electronic message center signs. A growing number of cities are allowing them with restrictions. There's also a lot of communities that prohibit digital billboards. Recently, the City Council of the City of Chicago, Illinois, adopted a moratorium, a 10-month moratorium on all electronic message center signs. Then during their deliberations, they determined that the signs that people were objecting to were digital billboards, not electronic message center signs. So the City of Chicago legalized on-premise electronic message center signs and continued the moratorium on digital billboards. Digital billboards are subject to spacing requirements generally at a local and a state level. On-premise signs are not. So we don't have any spacing requirements on South 9th Street telling people how far apart their on-premise signs need to be. Digital billboards usually have a standardized rectangular dimension. For interstate, it's 14 by 48. We have shown you in a graphic that you have at their places, just from a scale standpoint, the difference from a visual impact between what we would consider a digital billboard and an on-premise electronic message center sign. You'll notice one line there, it says the placement is on the property of the business establishment. That property is owned by the City of Salina. It is the City of Salina's sign, whereas digital billboards are typically erected along margins of freeways, highways, and other thoroughfares. Signs, if it's an on-premise sign, are owned by the user or owner of the property. At Ohio and Midway, that sign is owned by the user or owner of that property, which is the City of Salina, whereas in digital billboards, signs are owned by billboard operators and the space is leased to advertisers. If we took that property at Ohio and Midway and we leased it to somebody to put up a billboard to derive revenue from, that would be a billboard. But that is not what has occurred. It does make reference there to the one-time permit versus the annual permit. In the state of Kansas, if you have a billboard or a digital billboard along the interstate, not only do you have to get a permit to put it up, but you have to renew that permit biannually to maintain the sign there and pay the state of Kansas a fee. That requirement would not apply to the Ohio and Midway sign, even if it was on the interstate. And so the programming and control of those is the same. On many electronic changeable copy signs, things are broken up into segments because the entire message won't fit. Usually the entire message is contained on a digital billboard because it's so loud or so large. Both can be used to post community-oriented and public safety messages. Both are supposed to have automatic dimming controls to adjust illumination to ambient lighting conditions, and both can be used to post commercial and non-commercial messages. But the distinction is generally who owns the land, who owns the sign, and what the purpose of the sign is. So one thing we would ask you to ask yourself is if the screen at Midway in Ohio was turned off, would that still be a sign? And our answer to that is yes. It's an on-premise identification sign. It was put there to tell the traveling public where the Tony's Pizza Event Center is and to get them to turn at the right location. It does have digital characteristics. It does carry off-premise advertising signs or of those businesses, but one of the things that was discussed when we set up the public use sign regulations, that there could be a future sign at Salina Stadium. And that electronic changeable copy sign could advertise upcoming games and events at Salina Stadium. But the school district has some sponsors, and they have sponsors that help them advertise on their scoreboard in Salina Stadium. And they may wish to intersperse their messages about games with some messages about their sponsors. And the code that was written to allow that. And so there's nothing that is allowed at the Ohio and Midway sign that wouldn't be allowed if USD 305 put a similar sign up at Salina Stadium. But that would not make it a billboard, because the sign would be owned by USD 305. It would be on the premises of the Salina Stadium, and we would consider that to be an on-premise identification sign that just happens to have electronic changeable component to it. But I would qualify a couple things, is that the gentleman who spoke at your last meeting was not the applicant. The Planning Commission was actually the applicant on the text amendment. The other point I would make is that I believe it was a 5-4 split vote, but there was substantial opposition on the Planning Commission to the Ohio and Midway sign. They have been consistent about that. So the one thing that the City Commission did do was you granted the city exceptions as to sign height, as to the total size, and as to the area that could be devoted to electronic message center signs. But we recently approved permits at Central High and South High to put in new electronic changeable copy, what we determined to be identification signs that were identifying the location and the name of the school and happened to have a digital component to them. And if by chance the school district, for some reason, wanted to have some of their sponsors that help sponsor their athletic events and convey their messages on those signs, our code says that the sign shall be used primarily to convey information about community events, except that at sign locations eligible for pole signs, signs may also be used for off-premise commercial business messages. So that sign at Ohio and Midway conforms with that part of the code that was adopted, and a future sign at Salina Stadium that advertised upcoming sporting events, but also interspersed it with perhaps an ad for one of their sponsors. We would still classify that as an identification sign on the premises of Salina Stadium.
So sponsors are exempted?
They're not exempted.
I don't see the difference between, if Coca-Cola's a sponsor, I don't see a difference between a Coca-Cola sign, whether they're a sponsor or not. I mean, if sponsors are exempted, that's one way around it, but if I'm driving down the street, I just see an ad for Coca-Cola. And if it takes, I don't know what the percentage of off-site premise advertisements it takes to make it a digital billboard as opposed to a EMCS. It wouldn't matter if sponsors are exempted, and all of these folks on our billboard are sponsors.
But by our definition, that cannot be a digital billboard, because the sign is on property owned by the City of Salina, and the City of Salina owns the sign. If it's a digital billboard...
It's leased to someone else who actually controls and operates it. I forget the name of the company that is managing
Yeah,
TPEC.
we have a management agreement with
Yeah.
them, but
They're the ones who are actually controlling what's on that sign.
they're essentially our agents in doing that, but yes.
So we have leased it, I mean, the example, we have essentially leased that, right, there may be technicalities here.
Right.
But for sure, it looks like we carved out something for ourselves and wouldn't let someone else have.
And I'm not going to disagree with the appearance, and what I was going to say is, having said everything that Dean described, the appearance still remains. With respect to that sign, we own it. They're operating it on our behalf, so technically I wouldn't say that we've leased it to the management company. They're just managing our facility in an agreed upon way for an agreed upon compensation.
So if the 5 ads that I saw are not from sponsors, are those then off-site ads?
Those would be off-premise commercial business messages.
Which would make that device a digital billboard?
It would not. It would make it an on-site identification sign that was also running off-premise commercial business messages.
Right. But that, if I drop one drop of blood in spinal fluid, it's bloody spinal fluid, whether it has 1 drop or 100 drops. Spinal fluid is either free of blood or it's got a little tiny bit of blood. And this has a little bit of off-site ads, which by this list, and it's a good list, I don't see why it can't be EMCS. And if you add one thing to it, it moves across the line to a digital billboard.
It just isn't an all or none kind of thing. It is very nuanced. I mean, if you looked at the ordinance we presented to you, everything is very nuanced. The distance between billboards, the types of uses that are allowed to do this, and it's not just us, the city. I mean, school districts can do it, and even on some of the interchangeable message boards for banks, if they're supporting United Way and the United Way campaign, they can add United Way, be part of the campaign or something like that to their interchangeable message signs. So it's not just the school district or us. I mean, there are other interchangeable electronic message signs in town. Maybe the graphics aren't as bold or as identifiable, but I think one of the other keys it just comes down to is a billboard. If it's not on an electronic billboard, it's just a giant sheet of canvas or digital display. A sign, an electronic message sign, when that sign's turned off, it's still a sign. Like whether the LCD screen was there or not, we would still run it through the whole course of sign criteria.
It's still a sign, but it's not a sign with bright lights changing every 4 seconds, distracting drivers. It's
if
just a
that's-
static sign at that point.
But the city of Salina allows off-premise electronic message center signs. We just issued 2 permits, one for South High and one for Central High, but those are
So should we expect to
on-premise.
see United Airlines advertised in front of Central High School?
I don't know.
I mean, if so, I would think that would be not up to the same
Because
aesthetic quality that I would want for our
The legal
school.
advice that courts and legal advisors give is that you need to regulate the characteristics of the sign itself and not worry about trying to regulate what the content is on the sign. And so what we're trying to convey, and
So, but that's the
litmus
case-
test for us is that, and having consulted with the highway beautification coordinator, if I put up a digital billboard on Crawford Street, I have to get a permit from KDOT. But if we took this sign that's there at Midway in Ohio, and we moved it over to Crawford Street, you would not have to get KDOT approval for it because they don't consider that a digital billboard because they don't require permits for what they describe as on-premise signs, advertising activities conducted on the property on which they are located, including entertainment provided thereon.
But that's not content neutral.
Well, it is an on-premise sign, and
But you
that-
referred
that's,
to what it's advertising, and that references the content. It's the same thing for the signs, the sign ordinance we have for our yards. We decided you can advertise whatever you want, you just can't have more than 3 of them or 4 of them, whatever it is. I forget how many. And we took the risk, okay, somebody may advertise something we don't want, but we figured in this community people wouldn't do it, but.
as a matter of fairness or policy, if you want to revisit that and change the decision that you made, that is fine, but you're not.
No,
you're
well,
not, it is legal to distinguish between on-premise electronic message center signs, and digital billboards.
Well, that's where I prefaced, this would not necessarily, it wouldn't affect my views on the aesthetics of electronic signs in our city limits. My only concern is that the distinction that we're making between what the applicant wanted to present and what we already do seem just a little hazy. Well, that seemed very hazy to me. And it looks like we've carved out a special characteristic for the signs we own, or in our school zone. It just, I could see how the applicant, made the statement that, we're not treating our own sign. Plus, the change rate on our sign is actually rather fast if you sit there and just look at that sign for about 15 minutes.
Dean, do you know, as part of that approval, did we impose a regulation on the cycle rate?
No, the city commission chose not to.
Okay.
But that was...
As the owner of the sign, we may have an opportunity to...
As the owner of the sign, or as revisiting the subject generally, the generally accepted industry standard is an 8 to 10 second change rate. When that was presented for the city commission's consideration, the city commission chose not to impose that on the sign.
But sometimes we assume that staff will use generally accepted principles without without mandating it.
And we certainly can. I mean, and knowing what we now know, that bears revisiting. And your point remains, whether it's technical definitional issue, the perception remains the same. And so, if we proceed as originally approved, the direction to the planning commission is to consider a full-out prohibition.
Right.
If you, in knowing what you now know, would like that to be broader, then we probably need to provide alternate direction and a prohibition.
No, my only concern is that the sign on Ohio Street be legally and morally conforming to what we've established.
And it is either as the owner of the sign or as the governing body of the city, the city commission is free to revisit the issue of minimum dwell times, and you are free to limit the output of the sign to some prescribed light limit. We simply advised the commissions that we don't currently own any light meters, and it would require us to invest in light meters, and it would require us to go out and monitor signs. The good news is that in Wichita, their moratorium was a result of citizen complaints about digital billboards that staff had issued permits for. In Chicago, the moratorium was a result of citizen complaints about digital billboards that staff had issued permits for. And in some cases, they were put up without permits. The good news here is we don't have any, and we're not about to issue any permits for them. And if you decide that you like them and you want them, then they can be accommodated. But the good news is you can make that decision with all the information we provide you instead of based on complaints.
That decision I made 2 weeks ago, I just want to make sure the one sign that we own is not a glaring.
It is not non-conforming to any code. What it is conforming to is, I believe that the sign is probably brighter than any foot candle standard that the gentleman was referring to. I also believe that the 4-second change time is not the norm. But we currently don't have a regulation for change time, but that was one of the points that Mr. Scragg made was, right now the motion was to initiate a text amendment to initiate a ban. If you want our investigation or options that we bring forward to be more expansive than just a prohibition, and you want to talk about things like interval times and brightness limits and those things, those can be brought forward, but we would have to modify the direction that was given to consider a ban.
I'll leave it to the good judgment of the folks operating the sign for right now. If they read the paper tomorrow.
I just have a question. and I probably, my mind may have wandered just a little bit there, but is there any way, I mean, continue on with the prohibition on the digital billboards, but at some point revisit, say, like the change rate on the on-premise signs, so that we could, talk about an 8 to 10 second change rate on those signs? I mean, because I understand about the exception that that we've carved, that, and I have a sense of that, but is there any way that we could, add that language about the change rate?
Well, there's two options. I mean, and I guess I'm having a hard time with this option of things that we've carved for ourselves, because it's not just us. There are other electronic changeable message signs in town. So as far as this sign goes, I mean, as the owner and operator of the sign, we can address the timing of those right now. Like, Mike can call tomorrow and say, we think those need to slow down. If you want to in code address under electronic changeable message signs that there be a mandatory timing to that, then yes, that would be a text amendment, and we can go back and address that and have those moderated across the board. But each time these are brought to you as well, you have the chance to address how the commission would like those handled.
And it may go without saying, but to address it in the way of a text amendment obviously extends beyond just the sign we own to all the electronic changeable copy signs that are currently and will be future and installed in the future in the community. And if there's merit to the fact that it's distracting, and if you're trying to keep up with the message that hinders you if you're a driver, then that probably has merit beyond just us adjusting our own sign.
And I think that's where I'm headed with that, if that's the industry standard. And I believe you gave us some information on, was it a Wisconsin study that did, that dealt with distracted drivers?
There's been a subsequent study from Texas A&M, and we have copies of that. So the one thing I would just note, and this is from the International Sign Association, which is the largest advocate for signage in the United States, but they are the provider of that side-by-side comparison. They provided that for educational purposes. They actually recommend that cities treat the regulation of EMCs separately from digital billboards, and in their material they say that electronic message center signs and billboards, each type of sign has very distinct capabilities and purposes. Each targets a specific audience. Each has traditionally been treated under separate legal and regulatory regimes. So it is the expectation and even the recommendation of the International Sign Association that on-premise electronic message center signs be regulated differently from digital billboards, and that is the expectation of the industry. But we would be happy to revisit any of those things. The other thing I wanted to point out was, at least as it was proposed or requested by the parties that submitted their permit applications for digital billboards, was that in the case of the sign at Ohio and Midway, there was specific design for that sign was presented. There was notification of neighboring property owners. There was a public hearing in front of the Planning Commission. Those neighbors came. Those neighbors also came to the City Commission meeting, and that particular sign was reviewed at public hearings and voted upon by the governing body. The regime that they would like for digital billboards is that there is no public input, there's no public notification. I submit a sign permit and the sign goes up. And there's no notice, no opportunity to be heard, no public review, any of those things. That is what would be the regulatory regime that they would want to see. And so, for better or worse, the Ohio and Midway sign was publicly reviewed. There were public hearings. Neighbors had input. Some of their input resulted in a shield being put on the sign to help light spill from going to the east across Ohio. And so the process worked there. But if you set up a process where a digital billboard is simply permitted through a sign permit, you are not going to have that public input. No advance notice, no opportunity to be heard.
So if I don't want to move off that topic if you're not ready, but if I could add one clarification, I'm going to put the city attorney on the spot here a little bit, but, previously we advertised a text amendment as such that it would regulate digital billboards, and it came back to you as a recommendation for prohibition, so we concluded that didn't synchronize with what was advertised, we couldn't take that action. If we now go to the planning committee, if we now initiate a text amendment for the stated purpose of a prohibition, and we come back to you as a governing body, and the conclusion is, well, rather than a prohibition, I'd entertain digital billboards in very limited circumstances, we may be going back to the planning commission for a third time, because we advertised a prohibition, and that's not where we ended up. So, while we're talking about it, just want to
just to
verify.
be clear, I was in favor of the total prohibition. My only concern is that it appeared to me that the sign that we own was actually a digital billboard in EMCS clothing.
No, I completely understand it, and I wasn't directing my comment to you. The entire commission, it's kind of difficult to ask you what you might conclude, when it comes back to you, but if we head down the path of a prohibition, you're essentially going to have the opportunity to vote yes or no on the prohibition when it comes back to you without much more latitude.
That's correct.
Well, I think staff's question was, and one of the reasons we didn't advertise until tonight, knowing that this may come up, is if we're not going to do a prohibition and you would like us to do something else, I guess now is the time to give us that direction, or we can continue down the path that we were at.
Proceed as directed.
Yeah.
From me.
I think you continued as directed, but maybe I heard that as an additional text amendment to on-premise signs, we may want to extend
The
the
cycle rate and some of that
Yeah.
information.
flash
Yeah.
rate,
Okay.
to 8 to 10. I don't know how the group feels about that.
Yeah, most of the EMCS signs we're talking about are considerably smaller, and I don't think have as much of an impact on a driver. I mean, I'd have to go look. I mean, you have American State Bank on Ohio, Bank 6, Belmont Christian Church. I'm just going through my head. I can think of 6. The ones that would bother me more are the ones that scroll, because I'm trying to read it and I miss the first part and I'm trying to look over my shoulder to see something, But I think the regular billboards, or the signs, I should say, on-premise signs we're talking about are smaller, and I think much less distractive to drivers than the large billboards would be. So I'm going to do a little more looking when I drive by them to see how long they're on, but I'm not sure if they're on for 4 or 5 seconds, it's really a distraction.
Commissioner Davis, I think you started with a clarification that might have led you to a reconsideration. I think I may have just led you into reconsideration of that topic, and I don't want to do that inappropriately.
Well, right now, it's been sent back to the planning commission with the assumption that what will come back is prohibition, which was the end result that I personally wanted. Again, my only issue is whether or not we're treating our own sign quite preferentially.
Right. I think the preferential treatment for our sign is the size. We did, as part of that initial approval process, approve a larger sign than the code might otherwise allow. Other than that, I think it's an electronic changeable copy sign like anyone else could apply
Right,
for.
it was just how the off-site advertisements were allowed on that sign without changing its definition.
Off-site advertising is allowed on the other changeable copy signs as well.
Exactly.
So if the bank is sponsoring United Way, they can have that on there. So it's not just us.
But we keep using the example of sponsoring, and I'm not sure that the advertising that's happening on the Tony's Pizza Event Center directly correlates to events at the center or sponsorships. I think some of them may just be straight up advertising.
But Kansas Wesleyan or the schools could have something to that same extent, correct?
Well,
I don't know if those 5 that I saw are sponsors, and I just honestly don't know. But it was been building in a while.
is it fair to say that for this evening's purposes, certainly anticipated that there needed to be a certain level of conversation before you or anyone else might have been expected to make a motion of any kind, reconsideration, otherwise, whatever. And are we to understand that that conversation having occurred, there is no further discussion or direction differently than was authorized at your meeting last time?
100% correct.
And that, am I correct that we're clear then on how that we would want to publish that
Correct, we are.
notification?
My only follow-up
We're speaking,
question.
when we speak of publication, as maybe you know, we're speaking of the public notice of the Planning Commission's public hearing on the requests. So,
My only follow-up question is, at this time, would you like us to look at making a text amendment to address the electronic changeable copy sign timing, or would you rather work through this process? Because they don't need to be dependent on one another. As we get through this process and decide how we're going to deal with that, then decide if we'd like to address those.
and that's the discussion I was trying to
Avoid.
keep from occurring.
Sorry. I just want to get something done.
Only to the
Amen,
extent
Laura.
that we're not lapsing into
Thank you,
a
Greg.
matter that is not before you.
Okay.
Now, if you wanted to say, yeah, we're here, we want to go and pursue this further tonight, then you've got your two-thirds majority capability of doing just that. If it's something that you've identified in the course of this conversation that is, you believe, warrants further discussion as an agenda item and possible further direction procedurally, then that is certainly.
I don't see where it's caused a problem. I'm not sure why we look to create a
In my
bar
opinion, yeah,
problem.
we could
Let's
steer
ju-
it away,
Yeah.
steer away from it to another day. And I guess at the 4-second and a small sign, you could make an argument that that's less of a distraction than something that's there too long. So, yeah, I would
If
save
you're
it
trying
for
to
another
read
day.
everything on that screen in 4 seconds, it's hard. I didn't realize, and I wouldn't have never have known if we had not received the information 2 weeks ago. And I sat there full expectation of, well, this is going to be a long 10 seconds, and 2 signs had gone by. I said, whoa, that's kind of fast. I think that's something our staff can address in the future.
The other option is, something that staff will do regardless of action that you take, so we can share this conversation with the Planning Commission, and they could choose to initiate the text amendment on their own.
Thank you all for indulging me.
Thank you. It's interesting to hear all of this further distinctions. Other business?
I have 2 items, Mayor Ryan. I had reached out to Mr. Scragg and indirectly to Mr. Kowak about the work that's being done on South 9th Street between Republic and Cloud, because I've received a lot of citizen complaints about the uneven surfaces and the holes that could not be avoided despite traveling slowly and making best efforts. And I think that, I don't know which of you would like to give the update, but I understand that there's maybe some progress to report on that front.
Sure, and Jim may disagree with me, but in my experience, that's some of the roughest subgrade I've seen exposed by cold milling in a long time. So, but Jim and Public Works have been responsive, and I think he can speak to what's taken place recently.
Right. For the most part, we've had a really good summer to get construction work done, but the nature of that project is a little unusual in that we had a separate tree contract, a separate curb and gutter contract, and now we've got a separate surfacing contract. And we had to remove the edge of the street so that we could get the new curb in, and in the process of removing the edge of the street, we had asphalt that was over old bricks, and portions of it would break loose or break free during construction. And it's a pretty narrow section for us to try to maintain traffic, but and that gap on the outside of the road is, of course, where the water went anytime we did get any moisture. It got rougher than we anticipated. We thought we had a good plan for maintaining traffic temporarily with millings, which generally in the hot dry weather will stick together, and they're almost like a cold patch. Especially this last couple, 3 weeks, with the wet weather. Of course, the water congregates in the curbs and in the potholes, the low spots. It makes it difficult for people to judge just how deep they are. So when you hit one of those bad ones, you really notice it. And it got worse than we ever had hoped for. So first off, I want to apologize, but I wanted to let you know the sun is back out again, and that there was extensive effort today to fill in those particularly bad areas in the Republic Street intersection, and then a few of the other locations along there. A lot of the millings that have been beat out with the rainwater have been shoveled back into the trench. And the best news of all is that we do expect to finish that curb project later this week. And much like we have the rest of 9th Street from south going north, clear up north of Pacific, a milling and overlay for that section of 9th Street from Crawford to Cloud will occur hopefully beginning next week. So we're in the final throes of the deep potholes. A lot of effort went into repairing those to get us one more week. We're not expecting any more rain, so I want to thank everyone for their patience, and really hopefully in the next few weeks you'll see a big change that'll make all the rough stuff you've dealt with this summer worth it. So
Thank you. Thank you very much. I thought that was important to share because I have gotten several calls on that. The other thing that I'd gotten several calls on, and it kind of relates to one of the items in the city manager's update, was you had sent us an article from Hutchinson regarding private citizens asking for the Reno County District Attorney to investigate allegations and rumors of preferential treatment within the Hutchinson Police Department. Well, I don't have anything about the police department, but I have been getting considerable calls I'm still getting considerable calls and comments for an independent audit of the whole animal seizure and cruelty case. Specifically, things that people have asked for have been timelines for all parties, invoices of amounts spent on veterinary, boarding, legal, copies of correspondence between senior city staff, some of the allegations mentioned in the William Chevy email in regard to vendor payments being suspended and credit cards not working. And at any rate, my question to you is, obviously, I think it was Lori Troe that reminded us all that the citizens are our boss. Then comes us, then, everybody else. My question is, can Salina citizens, is that something that if we choose not to go forward with an independent third-party investigation, audit, whatever you want to call it, is that an avenue that's open to Saline County citizens as well as it is to Reno County citizens?
With respect to a third-party investigation, I do not know. I think my understanding of what occurred in Hutch was they just raised concerns that got the attention of the prosecutor, who then chose to take it under their authority to proceed. In all honesty, I guess I'd have to go back and reread that article. I wasn't aware that was a petition or a...
I think it was a citizen-initiated...
Yeah, well, I think it was the result of, complaints and concerns that were raised to the prosecutor, who then, I think the prosecutor was interviewed in that article acknowledging that while he wasn't jumping to any conclusions about the police department, he felt compelled to investigate.
Okay.
So my understanding is that's how that process occurred.
Okay. Okay, thank you, because this will be my third time to request that, and if I need to make it in the form of a motion, I'll be happy to, but I would like to request that we put a request for, or at least a discussion for a third-party audit on the agenda for next Monday. Do I need to make that in the form of a motion to get that added to the agenda so that it's on the record?
Who would you see doing third-party audit, I guess?
I honestly don't know at this point. I don't know if that's if you can request a Kansas Attorney General's office if there's a third party that can perform that audit. But,
And as I was listening to you go through things, and I understand, timeline and invoices and some of those things, and I understand the citizens' concerns, and I don't think that would be bad for us to see, but I think, and somebody else may have to step in here, but with what's going on and with the personnel issues and with what's going on in the courts, I'm not sure if it becomes an issue to have that out and, to have that public right now. I mean, once everything's said and done or whatever, I think we can look into that, but I'm a little concerned about some of that, being brought out now. I'm not sure where that would throw us as far as into some issues with what's going on in the courts.
But first and foremost, as it relates to the personnel matter, the person that probably needs to answer that question is the legal counsel you just authorized engaging this evening. Just to not, to be mindful of the process and disclosure of information. Beyond that,
I guess I agree with Commissioner Oppik. It seems entirely premature to initiate anything until we see the results of both the court, the actions that are going on in the district court, and our own personnel results. And, then if we disagree with or see flaws or problems with the process, then it might be appropriate to consider other action, but not at this time.
I would just contend, and I understand that I don't have a consensus here, but I would just contend that this can be a parallel process, because at this point, we've had to take 2 actions to exceed spending authority for unbudgeted expenses, and I don't know if at this point if that looks like $140,000 or $150,000. I haven't seen all the invoices that we paid on behalf of the animals. I don't know what the invoices are in terms of legal counsel that we've accrued to this point. And I would just contend that any audit, it's going to, with the amount of material that would need to be reviewed, I don't see this as something that you'd, first of all, take a while to accumulate it and aggregate it and bring it together to even present to a reviewer. So, just in the effort to get it going, I think it's really important. We've had, I think, probably greater citizen engagement on this one issue than we've had on anything that I've seen in the last year and a half. And people are concerned, people have questions. I hear, new questions raised every day, and it's like, that's great, I hadn't even thought about asking that. And I feel like we owe it to the people that have been coming here every week to show them that we're taking them seriously. And that's the direction that I'm coming to this from.
And I guess I'd ask the citizens to be patient with us, and I do want to see some of that same information, and but I'm not sure the timing's correct, and I know what you're saying about doing it parallel, but I also have a concern that we're short a city manager or a deputy city manager, and we have a lot of things on our plate concerning the new market tax credits, the STAR bonds, and things that if we have a third-party audit, I have no idea how much time that's going to take away from staff that could create issues. I'm not sure doing a third-party audit now makes any difference than if we do that in 60 days. That's just my opinion.
And I do understand that, and I just want to confirm with Mr. Scragg, as well as all of us and the people who are watching at home, that we have, made the offer to Mr. Scragg if he does need additional staff support, because I understand you are juggling a whole lot of things on your plate right now, that we have made the offer to get you the resources that you need to do in order to be able to do what you need to do. So I just want to confirm that we are, I know that I've made that offer, and I felt like we all had that same perspective, that we want to give Mr. Scragg the tools that he needs to do the job well.
And I took you up on that this evening. I mean, when the opportunity presented itself with respect to development strategies,
Exactly.
that's why I brought it to you. We already have outside counsel in the form of bond counsel, financial advisor, and bond underwriters as it relates to the STAR bonds, but it still requires management of that process, and I honestly don't know who. I certainly wouldn't bring in an outside consultant to do it, and we don't really have any other staff to hand that off to. Same way with new market tax credits. With respect to the information that you indicated, the one piece of information that already exists and probably doesn't directly relate to personnel and is the invoices. I mean, with
Right.
respect to how much we've paid for boarding and care, those animals have been, and they're no longer under our custody and care, so I think that number is at least capped at this point. I don't know it off the top of my head, but I can get it for you. And legal expenses, if you want me to keep you posted, I can do that as, we typically only get invoiced once a month, but I can make you aware of that as well.
That would be great. I'd really appreciate that. Thank you.
Is there any other business? Is there a motion to adjourn?
So moved.
Second?
All those in favor?
Aye.
We're adjourned.
Talked to Dee Dee the other day.